Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riad.
Dr. Nauman Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
Good afternoon, good morning, good evening to all joining us from different parts of the world. I am Dr. Nauman Riad, the Chief Convener of the Global South Network and a lecturer in law at the Leicester Law School, University of Leicester. It is a great pleasure to welcome you to today's lecture organized under the Global South Network Judges Guest Lecture Series.
It is a call for a distinct and transformative Caribbean jurisprudence, one that is locally, that is to say both territorially and regionally rooted, rights-focused, and ideologically emancipated from what I call a no longer useful colonial set of legal legacies. So for English and European powers, colonial powers, the Caribbean may have been seen and used as a tourist getaway, even when it hosted plantation economies built on forced labor and epitomized in the use of indentured labor, trafficking in humans, and chattel slavery. After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? If you came upon a series of lush islands with white sands and beaches that are caressed by warm turquoise blue waters. But what did they do? They enjoyed the bliss and exploited the people and lands for their own benefit. For locals and for commentators from the global south, in the Caribbean, they colonized, first, of course, the indigenous, the first peoples, and then imported forced labor in our region. Their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane and cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the seas and through the surf that these colonizers came in their boats, landed on the Caribbean's pristine sand beaches and turned their turquoise waters, their Caribbean seas, red with the blood of so many innocents. However, not only were peoples and lands and resources colonized and exploited, and the point of today's talk is about the fact that the colonizations of our legal imagination has also been an enduring legacy of the colonial history of Caribbean peoples. Insofar as we are considering, of course, the colonization of Caribbean legal imaginations, however, our freedom in this regard remains somewhat fraught. One notable feature of Anglo-Caribbean independence remains incomplete. And what is that? That is to say that there are still 7 independent and sovereign Caribbean states that take their final appeals to London, to the Judicial Committee of the Privy Council, and that is to say to the historical colonial courts. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imaginations? And have we been developing a truly Caribbean jurisprudence? What is this Caribbean jurisprudence? References to Caribbean constitutions being Westminster models had more to do with the need for, and I quote, psychological comfort than textual or lived realities. But Caribbean constitutions are not, were not, and are not replicas of Westminster. They are written, supreme, and justiciable. Courts had a constitutional power and duty to review legislative and executive actions. That is to say, governmental power. And so fundamentally, the Anglo-Caribbean constitutional order has shifted from British parliamentary sovereignty to constitutional supremacy. What may be this idea of Caribbean jurisprudence? Caribbean jurisprudence is developmental, is to recognize that it is an evolving process. What does that mean? It means that it is responsive to emerging cultural realities, unfolding socio-legal norms, and changing human values and experiences, all of which is happening in fluid political and legislative actualities. And so this idea of Caribbean jurisprudence, as we in the world, both North and South, exist in a time of change, of upheaval, global, that is to say, change and upheaval, this model of a developmental Caribbean jurisprudence that can be responsive to changing realities begins to have not just relevance for the Caribbean, but as a model relevance for the entire democratic global order and justice sectors. And so social context is critical to this idea of a Caribbean jurisprudence. Much like our Caribbean cuisine, to go a little further, because it would be quite heretical to insist that there is one Caribbean flavor. Caribbean peoples would revolt. And in the same way, there is no one Caribbean flavor, so too with our cultures and societies. Are there commonalities? Of course there are. Are there differences? Absolutely. And if so, in all these fields, why not in our jurisprudence? One size does not and cannot fit all. And that imperial magisterium, I hope, has finally been recognized as fraught, and attempts to return to universalizing of the law is a return to the imperial model of governance, which I think Caribbean independent constitutions have tried to put behind us. The global South, all of us from the global South, understand that difference is as natural as breathing and is to be celebrated. And that this is true as well in the field of law. There are in the global south states where multiple legal systems coexist. There is much at stake in this discourse on Caribbean jurisprudence, much more than just freedom from some no longer useful colonial ideas. What is at stake is the idea of freedom itself, the desire for state selfhood and state and self, society and individual actualization. Laws made and imported from across the seas and imposed in these lands have epistemological implications. And as judicial officers, I dare say, we are often, as Anais Nin said, we don't see things as they are, we see things as we are, and we are often still in an unemancipated state of mental slavery around these legal ideas. Our legal imaginations are still captured. The Caribbean states have opted for what I call a right-centric, rights privileging model of constitutional democratic governance that permeates all aspects of the state and restrains all exercises of state power. In the UK, however, parliamentary sovereignty is constitutionally normative. The UK is thus referred to as a parliamentary democracy. Understandably, very rationally actually, leads to how doctrines such as the separation of powers are epistemologically experienced and articulated. But if we get that, then we will also get that in the Caribbean, our point and process of constitutional embarkation, they are radically different. We do not exist in a parliamentary democracy where parliament is supreme. We exist in a constitutional democracy in which the constitution is supreme and normative. And thus, unlike in the UK, where among the three branches of government, the executive, legislature, and judiciary, the legislature is supreme, in the Caribbean, this is not so, and not intended to be so. If anything, the judiciary is primus inter partes, first among equals. Why? Principally because in Caribbean constitutions, courts can strike down laws and executive actions. For the CCJ, the courts are the ultimate guardians of democracy. They have the sole and singular responsibility of making sure that executive actions, actions, and laws, legislative actions, in the exercise of governmental power, meet constitutional standards. In this exercise, they privilege fundamental rights and freedom. We want to change things, but we don't always have the confidence or the courage. Neither do we necessarily want to take the risks or pay the price, because being pelted with big stones can hurt a lot. Caribbean freedom is still a fraught enterprise, as is Caribbean jurisprudence, yet just maybe the CCJ's developmental approaches to Caribbean constitutionalism can help lead the way. Thank you very much for your patience and your indulgence, and Professor Newman Riot, the opportunity to share my thoughts with the Global South Network and all of its supporters. Thank you.
I would also like to express gratitude to all our participants from Africa, Asia, Latin America, Europe, and beyond for joining this lecture. Your continued engagement gives a life to the network's mission, building bridges of knowledge and solidarity between the Global North and the Global South. At the Global South Network, we firmly believe that collaboration among judges, scholars, and practitioners across jurisdiction is not only desirable, it is essential. It enables us to learn from one another, to strengthen our institutions, and to advance a truly global conversation on justice, equality, and human dignity.
Thank you very much. Bye-bye.